A major retailer just bet big on a product that becomes federally illegal in November. Target, 72 stores, THC drinks on the shelf next to the Diet Coke. That sounds reckless until you look at who's doing it, where they're doing it, and why the law says three different things depending on which building you're standing in. This is a story about what happens when three layers of government do their own thing and regular business owners get crushed in the gap. I'm Patrick Nolan. Let's break it down. Target is headquartered in Minneapolis. Last year, they ran a pilot 10 stores, THC beverages, limited rollout. The pilot went well. On April 1st of this year, Target got licenses from the Minnesota Office of Cannabis Management to sell lower potency hemp edibles, including THC drinks, at all 72 of its Minnesota stores. Target now holds more lower potency hemp edible licenses than any other company in the state of Minnesota. Under Minnesota law, those products can carry up to 5 milligrams of THC per serving, up to 10 milligrams in a single beverage, 50 milligrams per package. Every one of those products becomes federally illegal on November 12th. Target knows that. Their lawyers know that. They signed a 1 year license anyway. So either Target believes Congress is going to blink before November, or they believe they can sell through the window and write off the inventory. Either way, the biggest big box retailer in Minnesota just planted a flag on a product with a federal death sentence already written. While Minnesota expands, Missouri cracks down. And the way Missouri is doing it should make you uncomfortable regardless of how you feel about THC drinks. Missouri's Attorney General, Catherine Hanaway, sent cease and desist letters to 33 hemp stores. The letters say their products contain more than 0.3% total THC, which would make them marijuana under Missouri law, not hemp. The letters also say the stores can't use words like cannabis, marijuana, weed, or kush, because those words allegedly confuse customers into thinking they're inside a licensed dispensary. About half the store owners are refusing to stop selling. They say they're federally compliant and they plan to operate until November 12th when federal law changes. J.C. Ciferis, owner of Dr. Smoke in Kansas City, put it this way, quote, Missouri follows federal law, which we follow as well. Nothing has changed. Not until November 12th. Here's the part that should make every attorney in the room sit up straight. The state lab did not test any of these products. Hanaway's office did not order tests from an independent lab. The lab results cited in those 33 letters came from complaints, and the complaints came almost entirely from one source, the Missouri Cannabis Trade Association, known as MoCan, a trade group of licensed marijuana businesses, the same businesses that compete directly with the hemp stores that got the letters. Last October, MoCan published a report called the Missouri Hemp Hoax. They sent secret shoppers into smoke shops. They had the products tested at labs run by their own member companies. They put together a list of stores they said were selling illegal marijuana dressed up as hemp. Of the 33 businesses the Attorney General targeted, 31 of them were on MoCan's list first. Think about what that means. A trade group representing one side of an industry did its own testing, published its own report, handed that evidence to the state attorney general, and the attorney general turned it into enforcement letters against that trade group's competitors. The state will not release the underlying lab data because the investigation is ongoing. As Sifris put it, quote, taking the word of our competitors might not be the best way to approach it. Law enforcement is supposed to run on evidence. They have no clean chain of custody, and the MoCan tests are hopelessly contaminated with self-interest and bias. Zoom out. November 12th is the date everything converges on. On that day, a provision Congress passed and the president signed takes effect. Any hemp derived product with more than 0.4 milligrams of THC per container becomes federally illegal. That is less THC than you'd find in a poppy seed bagel's worth of hemp. Compare that to what's actually on the shelf today. Minnesota beverages carry up to 10 milligrams per container, edibles up to 50 milligrams per package. Virtually every hemp THC product sold in America right now is above the new federal line. This was a rider slipped into an agriculture spending package, attached to a deal to reopen the federal government. A $180 million industry is about to be regulated out of existence by a provision that almost nobody outside the cannabis press read. Bipartisan lawmakers in the House and Senate are pushing for a delay. Congressional leadership has not given the delay any traction. As of today, November 12th is the date. Back in Missouri, House Bill 2641 sat on Governor Kehoe's desk all last week. Friday came. Kehoe neither signed nor vetoed. The bill became law automatically. Every hemp seltzer, every gummy, every edible above the new THC threshold is coming off Missouri shelves on November 12th. Here's the catch: the only way those products stay legal is inside a licensed marijuana dispensary, which means the same marijuana dispensaries whose trade group drove the Attorney General's enforcement action are now the only businesses allowed to sell what their competitors used to sell. In the week before the deadline, Missouri hemp farmers and retailers hand delivered 10,000 letters to the governor's office in a single day. Consumers, employees, business owners, farmers in person. Jay Patel of the Missouri Hemp Trade Association says the hemp beverage industry alone generates $75 million a year in Missouri. HB 2641 wipes it out. Here's what I want you to take away from all of this: you do not have to like THC drinks. You do not have to think hemp beverages belong next to the energy drinks at the gas station. That is a policy debate, and reasonable people land on different sides of it. Here's the harder problem: the law stopped being uniform. Federal law says one thing, Minnesota says a second thing, Missouri says a third thing. And inside Missouri, the enforcement evidence is coming from a trade group whose members stand to inherit the market once the competitors are shut down. At that point, you're running on the rule of whoever buys the best report. The hemp industry, whether you love it, hate it, or do not care, needs clear, unified federal guidance, not a patchwork where a retailer in Minneapolis is operating a legal business while a smoke shop owner in Kansas City gets a letter from the Attorney General based on lab results supplied by his direct competitor. When the evidence base is controlled by a financially interested party, you're watching something closer to a cartel running a protection racket through the state's letterhead. Americans deserve better than that. Small business owners deserve better than that. And the lawyers, the regulators, and the legislators who are supposed to be the adults in the room deserve to be held to a higher standard than whoever funded the last lab test. I'm Patrick Nolan. That was Pat Talks Law. Like and subscribe. See you on the next one.